Hi, I'm Lauren with Cadillac Law. I'm a Texas lawyer and I'm here to teach you about the law, specifically in Texas, and hopefully make it fun and interesting. I am not giving legal advice, and nothing in this video should be considered to make an attorney-client relationship between myself, my firm, or any of the viewers. I just want people to have access to the information that us lawyers spent tons of time and money to get access to. And of course, if you have a legal issue, I want you to call my office at 972-845-1200. As always, before we get into the good stuff, make sure you hit subscribe. It is free, it costs you nothing, it does a lot for my self-esteem. And if you think I'm at all funny or interesting or you learned anything, hit like on the video, please. It helps the algorithms. If you have any questions, put them in the comments box so other people can learn as well. I'm trying to spread the knowledge. I need your assistance. So today we are talking about dispute resolution. There are many different types of dispute resolution. The first one that comes to mind is litigation. You have a dispute with someone, you sue them, you litigate. And that is an interesting way to approach life. And certainly as a litigator myself, I have helped many people use that approach. However, it is always my preference to do an alternative dispute resolution before we have to go all the way to a trial. So for those of you that own small businesses and you're able to write your own agreements, I highly recommend, that in your agreement you have a clause requiring a dispute resolution mechanism prior to any lawsuits being filed. I've been on both sides of that clause in a courtroom, and it does work and it does get applied. So you want to make sure you have that type of language in your agreement. It will help save you a ton of time and money. So there are two types of alternative dispute resolution that I can think of off my top of my head that are legal, because there are tons of types that are not legal that involve fists and guns, and don't do those, okay? That is not dispute resolution. That is a terrible idea. Alexander Hamilton was like in a shootout. That's how he died. Or what is a gunslinger? Anyhow, don't do those. Mediation or arbitration. So personally, I prefer mediation. That is because mediation is relatively casual, and I am a relatively casual person. In a mediation, you can expect each party getting to tell their side to a neutral mediator, the mediator hearing it, and then going back and forth between the parties to see if they can find a resolution. I know some excellent mediators out there, Ken Rubenstein, hey. And then I know some pretty terrible mediators. I'm not going to name names, but you know who you are. The mediation itself usually costs about $1,000 per party, and it's going to take about, the actual mediation will take 4 to 8 hours, but the whole preparation and everything is going to take less than 40 hours out of your life. Arbitration, on the other hand, is a lot more formal. It is more expensive. You have to pay a professional arbitrator who is usually someone who was a former judge at a very high level. And they are not cheap. You go through the American Arbitration Association and you're able to kind of choose your arbitrator. Both the parties kind of submit their favorites, and if there's any that match, they choose that one. And then that very much goes on like a trial. So it's a lot more like litigation, and it looks a lot more like litigation. It feels a lot more like litigation. However, usually in the end, you're having an arbitration, either an agreement that y'all have negotiated or something the arbitrator came up with for you. And those can be binding or non-binding. So if you're writing your contracts, think about this. Binding is like, here's what the arbitrator said, that's it. We don't get to go to a judge and ask otherwise. Non-binding, hey, I don't actually like what we agreed to here, what this arbitrator said. Let's go to a judge. So when you're writing your contracts, you want binding. But when you're a consumer, you want non-binding. So think about that. I don't love arbitration because of the cost. So I love it as a cost deterrent in an agreement. As a business owner, it's a great clause to have. Hey, we got to go arbitrate this, because it's going to cost that consumer at least $8,000 to $10,000 to do the arbitration. Whereas if you actually want to get disputes resolved, you can go see a mediator, and you're looking at more like 1,000 to 2,000, and then you can get your issue resolved. So I guess in that sense, it would depend on if you want to continue your relationship with the person after you get the issue resolved. So I don't have much more to say about alternative dispute resolution. I really do like it. It is a great business tool. There's great language to use in contracts for business. And I think it's a nice way to resolve problems without having to go full-blown litigation. Full-blown litigation can get really rough and nasty. That's it for today, folks. Give us a call if you have any questions, 972-845-1200. Have a good one.